Thank you so much for having me at this important tribunal. I'm a lawyer for the Global Legal Action Network and also a consultant at Bindmans LLP. And for the last almost 2 years now, I've been part of the legal team representing Al-Haq in its challenge against the UK government's continued decision to license weapons sales to Israel. Just briefly, by way of extremely brief background, Al-Haq started its challenge in October 2023. In September 2024, under threat of injunction from us, the government assessed that its legal obligations necessitated a cessation of arms sales to Israel, but it created a carve-out for UK components for F-35 fighter jets. Al-Haq's challenge was heard in the High Court in May of this year. Al-Haq was unsuccessful on all grounds, but we are currently seeking leave from the Court of Appeal to appeal. I want to begin by saying that it's been really quite shocking to observe how far this government is willing to create legal absurdities, to defy logic itself, to obfuscate, to employ every tool at its disposal in order to keep arming Israel. My testimony will address how, despite the existence of national rules giving effect to the Arms Trade Treaty, the UK government has, to date, been able to continue transferring lethal weapons, which it knows are making their way to Israel, despite clear and overwhelming evidence of atrocity crimes. I'm going to focus on explaining the flawed methodology that the government employed to make its assessments under the arms export licensing criteria, and how that methodology creates an inevitable, or we say predetermined outcome, which is the continued flow of weapons to Israel. So the UK's strategic export licensing criteria state that licenses must be refused if there exists a clear risk that the item might be used to commit or facilitate a serious violation of international humanitarian law. The criteria also stipulate that the government must not grant a licence if to do so would be inconsistent with the UK's other international law obligations, including the Genocide Convention. Now, the approach that the UK adopted in order to fulfill its legal obligations was essentially to do an incident-by-incident assessment. So rather than looking at patterns, they would, for example, look at whether one strike on Al-Shifa Hospital was unlawful, but they would fail in their entirety to assess whether decimating the whole healthcare system was unlawful. What's more, at the very outset of the conflict, this government decided, or the government as it then was, the Conservative government, decided that they could not assess whether there might have been violations without information from Israel itself as to what was being targeted and other operational information that Israel might have. They therefore asked Israel for this information, and Israel declined to provide it. The government deemed that that refusal was a reasonable one. This was an approach that was adopted by the current Labour government, and this set in motion the circular reasoning which saw the government repeatedly give the perpetrator of these atrocities the opportunity not to incriminate themselves. The effect of this approach is that no matter what Israel does in the conflict of hostilities, no matter how clear the breaches are, no matter how uniform the international consensus is, this government will not find that any of these strikes even possibly violated international humanitarian law unless Israel tells them its version of events. Al-Haq's case in these proceedings was that it was wholly unnecessary to impose such a requirement on the IHL analysis, because obviously the clear risk test could be assessed through monitoring patterns of attack, through looking at statements of clear genocidal intent by Israeli officials, and generally from drawing obvious inferences from what Israel was actually doing in Gaza. Nevertheless, the government's methodology led to perverse findings. In the course of these proceedings, the UK government has had access to video footage of the sniping and killing of a grandmother as she walked with her grandson, holding his hand, waving a white flag. Even this was not a possible breach of IHL. Likewise, the execution of Palestinians in their hospital beds by Israeli forces disguised as healthcare workers and disguised as healthcare workers and civilians. Again, not a possible breach. Massacre after massacre of children in their beds, not a possible breach. The whole-scale flattening of bakeries, not a possible breach. These are all examples that come from this very litigation, and in many cases, the government's own evidence, which it disclosed in these proceedings. By September 2024, which is the last time we had disclosure in this case, Israel had killed over 40,000 Palestinians and launched over 10,000 airstrikes on Gaza. The UK government had examined just 413 of these incidents, which we say is outrageous. And of those 413 incidents, it found only one possible violation of international humanitarian law. That possible breach was the World Central Kitchen attack that killed foreign aid workers. So that means that 11 months into this most deadly conflict, the UK government had not assessed that a single incident that killed exclusively Palestinians was even a possible violation of international humanitarian law. This, we say, is a calculated blindness to the sanctity of Palestinian lives. What's more, the consequences that flowed from this methodology were extreme. For the first 11 months of this litigation and this conflict, the UK government assessed that there was no clear risk that UK weapons might be used to commit or facilitate a serious violation of IHL. And that meant that weapons transfers to Israel continued unabated and in fact increased dramatically following October 2023. In September 2024, the UK government reached the assessment that the clear risk threshold was met, but even then it still departed from its own domestic rules in order to create a carve-out such that UK components for F-35 fighter jets still go to Israel if they do so via the international pool. This new decision itself shielded the very methodology from challenge, because by taking a new decision, Al-Haq was now precluded under the domestic rules of judicial review from challenging the prior decisions. Just another way in which the government sought to evade accountability. In respect of the F-35 carve-out, Al-Haq argued that these continued transfers were inconsistent with the duty to prevent genocide, and this engaged the key question in this litigation of whether the government had assessed the risk of genocide. This is how we discovered that, despite denying having done so to Parliament, the government had made an assessment under the Genocide Convention, and it had concluded that there was no serious risk of genocide. How, you might ask, could the government possibly have reached this conclusion in the face of everything that was coming out of Gaza and near international consensus on this point? The answer is through its flawed methodology. The government had said that, because of its application of its methodology, it was unable to find evidence of attacks on women and children and evidence of deliberate attacks on civilians in general, and therefore Israel could not harbour genocidal intent in its assessment. So in other words, the UK government stacked their genocide assessment on top of this rigged methodology, a methodology that is not even designed for meeting its basic obligations under the Genocide Convention. The last thing I'll touch on before I close is that, in addition to intentionally employing a flawed methodology, in the context of this litigation, the UK government has taken other steps to frustrate the rule of law and prevent their cooperation with Israel from being properly scrutinised. So, for example, in proceedings like this, there's what's called a duty of candour, which is a duty to disclose all material facts. We specifically asked for a research report that is chillingly entitled, and I quote, "Long-range shootings or shootings of minors," end quote. The UK, in contravention of its legal obligation, chose not to disclose that by way of these proceedings. In addition, this government has sought to introduce delay into these proceedings at every possible juncture. Also, this government has said one thing in Parliament and an entirely different thing in court, as Richard Burgon MP alluded to. And in fact, my colleague Garodo Quinn will make further submission to the Tribunal tomorrow, expanding on what we've learned firsthand about how the UK government has itself engineered an accountability gap and how they are now exploiting that gap to enable their support for Israel to continue unchallenged. So, in sum, in order to evade accountability for its actions in Palestine and avoid scrutiny of the UK's deep economic, political and military cooperation with Israel, this government has hollowed out its own domestic laws, as well as the procedural safeguards and protections afforded by the Genocide Conventions, the Geneva Conventions and the Arms Trade Treaty. The UK had a proud history as an architect of the post-war international framework, and yet the effect of the UK's current position is to severely compromise that very framework. Thank you.
Thank you very much. Questions from my colleagues? Yeah, go ahead.
Thank you very much for that, Charlotte. So just a quick question in relation to the reasoning of the court in their assessment of the F-35 case. Would you be able to give a short comment on that, as well as your own assessment of that, of the court's reasoning and its rationale?
Yeah, absolutely. So basically what happened in the case is that the UK government said that the F-35 carve-out was necessary and that removing its parts going to Israel would undermine international peace and security. And it failed in its entirety to submit evidence in open court as to why that was the case. But what happened is there were closed proceedings. So essentially that's proceedings where Al-Haq and Al-Haq's lawyers are not allowed to view the evidence, but there's someone appointed to represent our interests. And in the judgment, the court found that evidence that was submitted in the closed proceedings established the point that international peace and security would be undermined by the removal from that programme. That's one aspect of its findings. Also, generally in judicial review in the UK, the courts afford a great degree of deference to governmental decision-making, and that is especially true where national security is at stake. And because of the way that the government pleaded this case, in that it is core to national security, there was a huge degree of deference that was afforded to governmental decision-making. What the court said expressly is not, we endorse this approach, but actually the proper place for scrutiny is not the courts, it is Parliament. And so it's interesting to follow immediately Richard Burden MP after himself talking about how challenging it is to afford for accountability in the parliamentary setting.
Well, indeed, it is quite unfortunate how stuck we are in a circular go ask the other person type of thing. Would you like to?
My simple question is this. First of all, thank you very much for your evidence. How often do cases of international humanitarian law breaches actually end up with a case taken in a domestic court? I'm not just thinking about the UK, I'm thinking of other places where you've got a very distinguished record of taking up cases in different countries. I wondered if you had any experience on this.
Yeah, I wouldn't be able, I mean, I'll just comment anecdotally, but I think it's extremely rare. In the UK setting, for example, we're obviously the only case, and that's for a number of reasons, including the deference afforded to the courts, but also including how astronomically expensive it is to bring litigation in the UK, and how often this realm of decision-making, not just in the UK, but if we look at the US and other similar jurisdictions, is actually kind of cordoned off. Governmental decision-making as it relates to national security is one of the most hardest, like the most challenging thing to challenge in the courts.